The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, good afternoon, gentlemen. Judge Richardson, Judge Qualabong, and I are happy to see you today, and we're ready to hear from you. Mr. Williams.
Thank you, Your Honor. May it please the court, Ed Williams for the West Point School Board defendants. I'd like to reserve 3 minutes for rebuttal.
You can.
Thank you, Your Honor. There are 4 independent and alternative paths for this court to conclude that the district court had removal jurisdiction. 2 of those are under 28 U.S.C. section 1443-2, and 2 of them are under 28 U.S.C. section 1441. Only the 2 paths under 28 U.S.C. section 1443-2 are currently available for review by this panel, pending the outcome of the Supreme Court's decision in BP versus Mayor and City Council of Baltimore. However, because the decision in that case is imminent, we'd like to discuss those grounds for removal today as well. The court is amenable. With respect to section 1443-2, Congress has provided a federal forum to a subset of cases like this one, where federal civil rights laws are issued. And we submit that the most straightforward path to finding removal jurisdiction proper here is under the refusal clause of section 1443-2. That clause provides the basis for jurisdiction where a defendant has refused to do any act on the ground that it would be inconsistent with a law providing for equal rights. The district court erred by concluding that Title IX is not a law providing for equal rights and did not reach the rest of the analysis. We'd like to begin with that error. Title IX is a law providing for equal rights as cognized under section 1443-2. If for no other reason to begin, because the plain language of the statute informs us, first, that Title IX is a law as opposed to a constitutional provision, which was in Rachel, the Supreme Court decided was not a permissible law under section 1443-2. And it provides for equal rights. Specifically, Title IX provides for equal rights on the basis of sex. Of course, the district court read the Supreme Court's decision in Rachel as limiting the clause, law providing for equal rights, solely to laws stated in terms of racial equality. First, we submit that the Supreme Court's recent decision in Bostock, interpreting Title VII of the Civil Rights Act, informs this court that we must first begin with the text. And if the text is clear, we end with the text. Based on the plain language discussion that we just had, we believe that Bostock suggests to this court and informs this court that Title IX is a law providing for equal rights. We also submit, Your Honors, that Georgia v. Rachel does not foreclose this plain text conclusion. It does not foreclose this conclusion because the issue of whether or not a law that provides for equal rights on the basis of sex could meet section 1443-2's pronouncement was not at issue in Rachel, and indeed Title IX of the Civil Rights Act of 1972, educational amendments of 1972, were not even in force at the time that Rachel was decided. Rachel must be understood in its context. In Rachel, a group of sit-in protesters were charged under Georgia law with crimes, and they sought to remove to federal court under section 1443-1, which has a very similar law providing for language. It says law providing for equal civil rights, whereas section 1443-2 says law providing for equal rights. We submit that there is no meaningful difference, and no court has found a meaningful difference between those 2 phrases as used in those clauses. But the court then goes on to say what is in bounds and out of bounds for that particular clause. What is out of bounds was the due process clause and the equal protection clauses of the United States Constitution. Those clauses.
So just so that I think I understand the argument you're making. What's the best case that you have suggesting that we should read Rachel as narrowly as you suggest? Has any circuit court adopted your view that we should read Rachel so narrowly and the sort of subsequent cases as well?
Two responses, Your Honor. First, I believe that the Supreme Court and Greenwood, I'm at 825 in Greenwood, actually does offer some reason to narrow Rachel's conclusion. At 825, and Rachel and Greenwood, of course, Your Honor, were decided on the same day in 1966. In that case, the Supreme Court says that a precise definition of this clause, a law providing for equal civil rights, has not been reached by the court and doesn't need to be reached in Greenwood, and suggesting, because it was decided on the same day as Rachel, that Rachel most certainly could not have been in the way that might be suggested. So I think Greenwood, the Supreme Court itself, suggested that Rachel was not the end of the conversation as to what a law providing for equal rights could mean. The second response, Your Honor, actually has to do with a corollary. Title VI has been used as a removal provision, has been used as a law providing for equal rights under Section 1443(2) for proper removal. In particular, in a case called Lankler, District of Kansas case, where a school board removed a federal court under Section 1443(2) on the basis of Title VI. I bring up Title VI, Your Honor, because Title VI is, Title IX rather, is a statute that is duplicative of Title VI. I'm now paraphrasing the Supreme Court in canon, that Title IX is effectively Title VI, except that the words race and sex have been exchanged. And so if that's the case, it would strain credulity, Your Honor, or at least good modes of statutory interpretation to conclude.
Right, so go back again to my question. I understand those 2 points and the rest of it, but is there any court, I mean, preferably a circuit court, but is there any court who has adopted your reading? I understand you have an interesting argument about how we can narrow those cases and read them as maybe something less than the words they used. But is there any court that I can look to that has done that?
No, Your Honor, we are not aware of a court that has adopted this particular view of Rachel, but we also submit that this statute has been rarely interpreted since it's been in existence since the predecessor statute came to existence in 1866. So it's not surprising that there's no statute even since 1966 or case since 1966 that has adopted this particular analysis. And we think that if you look at Bridgeport Education Association, which is a District of Connecticut case, which I think does the most thorough discussion of the refusal clause that we found in case law, that case actually goes through and talks about the fact that the refusal clause should be read as not as broadly as possible, but should be read as on its own language, which is consistent with Justice Gorsuch's opinion in Bostock. That
Mr. Williams, let me ask you this. With regard to Section 1443(2), what state law did you refuse to enforce by firing the appellee?
So Mr. Blaming submits on his complaint that several Virginia constitutional provisions and Virginia statutory provisions required the West Point School Board to accommodate his misgendering or discrimination of the transgender student. Of course, we disagree with his interpretation of Virginia constitutional and statutory law, but on the basis of his complaint, Your Honor, we submit that Mr. Blaming contends that those statutes and constitutional provisions required something that the West Point School Board District refused to do. In fact, Your Honor, if you look at Mr. Blaming's complaint, just above the heading for paragraph 65, he states, and it labels an entire section of his complaint as defendants refuse any reasonable accommodation. And so he himself acknowledges that the West Point School Board has refused to take action or take an act that he has asked us, the West Point School Board, to take because the school board believes it is inconsistent with Title IX and its obligations under Title IX to ensure that the—
Go back for a second, Mr. Williams, if you would, because I appreciate Judge Floyd's question. You say sort of generically, state constitution and laws. What's the one that you think is closest as far as an argument? I'm not saying you're adopting it. What is the argument? What is the best state law that the school board refused to enforce?
So two responses. First, to directly answer your question, Judge Richardson, I think that the clearest would probably be the Virginia version of the RFRA, I think and that's probably what Mr. Blaming would most strongly contend was violated here. And so we would counter that is what the school board has, to the extent that it can carry the interpretation that Mr. Blaming suggests, which again, we don't adopt.
So tell me, all right, so take the Virginia version of RFRA. Tell me on what authority the school board is charged with enforcing RFRA, the Virginia version of RFRA. Like, what's the authority for your enforcement of that statute?
Well, again, I believe that Mr. Blaming contends that we are charged by to abide by it, by granting reasonable accommodations to him. In this case, allowing him to discriminate against the John Doe student here by refusing to use pronouns for that particular student while using those pronouns as the other student. Although
and I just want to make sure I understand your argument. From your perspective, are you charged with enforcing every state law that you're required to comply with? So, for example, if your school board member gets drunk and drives, right? So he has to comply with the DUI laws. But we wouldn't naturally say that the school board is enforcing the DUI laws, right? So compliance and enforcement are different. Help me understand why compliance is sufficient here.
That's right, Your Honor, and I would not contend that we are the school board is required to enforce every law that is required to comply with. And I actually want to zoom back out for just a moment, Your Honor, to respond to your question more fully to the text of Section 1443.2, which does not read the enforcement language that Judge Floyd and Judge Richardson that you're discussing. I believe what you're discussing comes from this court's decision in Baines, which was just before the Supreme Court's decision in Racial. Of course, Baines and the discussion of the enforcement or state officers' enforcement of a discriminatory law comes from a legislator who, in 1866, who on the House floor included this refusal language and said it would be used for this purpose. Again, I believe the Bridgeport Education Association case in the District of Connecticut is helpful here. Because what that case does or says is that what the legislator was doing, and what I believe Baines and Greenwood adopt or at least suggest, is that a refusal to enforce a discriminatory state law is kind of at the center or at a core way in which Section 1443.2 refusal clause might be used. But the refusal clause itself says any act that is done or that is refused to be done.
So, Mr. Williams, let me ask you a question. Even going that route is not the best place for us to look in terms of what the school board was basing its decision on, the letter that it wrote to Mr. Vlaming and explaining why it was terminating. And in that letter, if I recall, I think the only things that the school board said it was basing its decision on was its own policies. I don't think there was any reference to federal law in there. Why didn't, when you had the chance, your client had the chance to explain the basis of its decision, and it did so based on its internal policies, why wouldn't we limit our focus to that?
Your Honor, again, two responses. First, I believe that the letter cites the policies, and the policies cite directly to federal law in them. They cite to Title IX. So I believe we have incorporated Title IX into that letter by citing those policies. But I think a more direct response to you, Your Honor, is that it's a look at what the Supreme Court did in Racial and Greenwood. In Racial and Greenwood, it was the notice of removal, not some prior documents attendant thereto that provided the basis for removal. And I think that makes sense, Your Honor, in that the notice of removal here that the West Point School Board filed in the district court laid out what it is that the school board refused to do, which is to accommodate Mr. Blaming, to allow him to continue to teach French at West Point High School if he was going to continue to discriminate against this transgender student. And so we believe that it's the notice of removal that controls whether or not Section 1443.2 applies, not necessarily the documents attendant to the complaint. Of course, those are helpful, and we think they are helpful to us here because Mr. Blaming attaches those policies to his complaint. And those policies, Your Honor, directly cite to Title IX in the, I believe, the legal support section of each of those policies attached to his complaint.
Mr. Williams, let me ask you a follow-up to my other question. What federal guidance was the school board acting under beyond the guidance of Title IX itself in firing Blaming?
So, Your Honor, the school board, like any other public entity subject to Title IX or educational institution subject to Title IX, is required to make decisions that it believes are consistent with those laws. In this court's decision in Grimm, Your Honor, this court made very clear that Title IX precludes discrimination on the basis of gender identity, specifically with respect to transgender students. And the Grimm case had been percolating since well before Mr. Blaming was terminated. And so the school board, like any prudent educational institution, was watching the educational landscape and believed, based on the way that case was being decided, although it bounced up and down a few times, the way that case was being decided, that discrimination on the basis of gender identity against a transgender student qualified as discrimination on the basis of sex, and therefore that Mr. Blaming's discrimination against John Doe here qualified as discrimination under Title IX, and therefore needed to be remedied. And the school board chose to remedy that by giving him the opportunity to comply, and then when he refused to comply, by terminating him for that act.
So the answer to the question is you relied solely on guidance from Title IX?
Yes, Your Honor, that the school board relied on its policies, which are promulgated as an effectuation of Title IX, of course, and other statutes, but Title IX is the statute at issue that gave the basis here, and that is why it's cited in the policies. That's why those policies are cited in the termination letter. Your Honors, if it would be useful, I could spend a few moments talking about the color of authority section, or switch to the federal question jurisdiction, but I want to make sure I use my brief time as usefully for the court as possible. If the court's amenable, I'd spend 10 seconds talking about the color of authority provision, which allows not only for removal under 1443.2 for federal agents, that's PCOT, but also for federal officers, but also for their agents. So those who assist in that effort. And I see my time has expired. If there are no questions.
Yes, you have some time in rebuttal. Judges, any of you have any questions? No. All right, Mr. Langhofer, you may proceed.
Good afternoon, Your Honor. Good afternoon, Your Honors. Tyson Langhofer on behalf of Appellee Peter Blaming. May it please the court. Mr. Blaming filed his complaint in Virginia State Court, alleging claims exclusively under Virginia law. So defendants attempt to shoehorn this case into the very narrow exception created by 28 USC 1443 subsection 2. But as the district court correctly held, defendants do not meet the statute's strict requirements. First, Title IX is not a law providing for racial equality. And as Judge Richardson noted, no court has ever interpreted section 1443 to cover Title IX. Second, defendants are not federal officers or agents and did not act under color of authority of federal.
Mr. Langhofer, to your point, I mean, I think that's right. Does Rachel compel us to interpret 1443.2 to racial discrimination or racial matters?
Well,
I know there's not a case that says that, but the question is, we got a text that's broader. We got a case that refers to racial matters. Does Rachel compel that? Is that your position?
I don't think it compels it, Your Honor, because it was on subsection 1, but it does frame the reference. And everything from Rachel, every court since then has limited 1443, both subsection 1 and 2, to only racial claims. And the only circuit court to have addressed it, the Sixth Circuit in Clark, actually specifically held that subsection 2, like in Rachel, is limited to racial equality. And so I think if this court ruled otherwise, it would create a circuit split, and it would be contrary to every other district court that has addressed this, and every other district court has limited it solely to laws governing racial equality. And because of that, we think, and then you look at the historical context that Rachel laid out and that Greenwood laid out, we think that the analysis applied to subsection 1 and Rachel also applies to subsection 2, and that all of the courts that have applied it since then have gotten it right. And so because of that, the district court was correct and should be affirmed on its ruling that 1443 subsection 2 only applies to laws governing racial equality. But even without that, the defendants failed to meet the other requirements, very strict requirements of 1443. Specifically, the requirement of the first subsection, which provides that this was designed as a safe haven, a federal court safe haven for state officers that are acting as federal agents charged under state law for assisting federal officers enforcing federal anti-segregation laws.
Do you
and
think,
the Supreme Court,
just so I understand where we are, and I understand the point of Judge Quattlebaum's question, but our decisions in Wilson and Delavine, I may be mispronouncing that, do you think, read in light of Rachel, that those cases dictate that we find 1443-2 is limited to racial equality?
I think that is accurate. Given all of the when you look at the whole body of law governing these cases, it is limited. And in fact, every one of the cases cited by the defendants are all dealing with Title VI cases. They're all racial equality cases, and they all deal with desegregation. You look at Bolander, Burns, and Linker; those are all racial discrimination cases. And so we think that Rachel, combined with all of the subsequent decisions, including the Sixth Circuit's, does support the decision that this is limited solely to laws governing racial equality. But even if that were not the case,
Mr. Langhofer, let me ask you, I guess I'm asking you to speculate, why did the Supreme Court apparently abandon the, quote, racial language in the opinion of Chapman v. Houston Welfare Rights?
Your Honor, I can't speculate as to that. I don't know the answer, but what I do know is that when you look at the analysis that both Rachel and Greenwood engaged in, they specifically looked at the historical context and indicated that they believed that the intent was limited to racial equality. And I don't know why they specifically abandoned that there, but I think that given the history, the development since then, over 50 years since those decisions have been handed down, and that every court that has addressed this has limited it to laws of racial equality, I think it demonstrates that that they all understood it to be limited in that way. And again, I think it would create a circuit split with the Sixth Circuit if it was ruled otherwise here. But I think it's even, just as importantly, that if they're going to qualify under these clauses, they have to meet either the first or the second clause, and defendants cannot meet that. The Greenwood court was very, very specific as to the first clause. They indicated that you have to be a federal officer or a person assisting such officer in the performance of their official duties. And then the Greenwood court goes on to explain and give some examples. And the examples they give are just a regular individual who is specifically authorized as a U.S. commissioner to execute a warrant to enforce a racial segregation law, or to enforce a racial equality law. And so in that case, they're specifically saying, look, you have to be authorized as a federal officer or an agent to execute specific actions. And I think, again, all of the cases cited by defendants support that ruling, because Bolander, Burns, and Linker, they all involved racial discrimination, and every one of them involved a district court that specifically ordered a specific school board to take specific action,
So, go ahead and finish your sentence. I'm sorry. I'll ask it after that.
I was just going to say, or a federal agency. Every one of those cases dealt with a federal district court giving an order or a federal agency giving an order.
assume for the sake of discussion, just to go to the other elements besides what equal rights means, that the defendants get past that hurdle, and I'm not suggesting the outcome there. I'm just want to explore some of the other issues. Why isn't refusing to accommodate your client's request for religious freedom grounds under Virginia law? Why isn't that the refusal to do an act on the ground that would be inconsistent with a law providing for equal rights?
Because every one of the causes of action, Your Honor, are based upon the termination, the defendant's affirmative act to terminate. If they wouldn't have terminated, then he wouldn't have sued. This is a wrongful termination case, and every one of the claims deal with the damages and the remedies that come from the termination.
Isn't that a bit of a chicken or the egg? I mean, if you would have accommodated, if it would have accommodated, it wouldn't have terminated. So, those seem pretty intertwined to me.
So, Your Honor, I think the common cause case is an interesting one here. And so the common cause of the Eastern District, North Carolina legislators they enacted a redistricting law, and then they were sued in North Carolina State Court to stop the enforcement of that. And they removed it under 1443 subsection 2, refusal, and the district court denied that. And they said, look, you're not refusing to act, because what the plaintiffs there were wanting, they were wanting them to not enforce that law. And that's what North Carolina said. And the court said, no, you were sued because you enacted that law. And that's exactly what's happened here. They enforced this policy by terminating Mr. Blaming, and that then triggered the lawsuit. And so I think that reading that the Eastern District of North Carolina is consistent with what we're saying here, is that he wouldn't have had a breach of contract claim had he not been terminated. He wouldn't have had a Dillon rule claim had he not been terminated. And so the second clause does not apply.
How would you have us, so just help me understand, this is a difficult question. How do we draw that line? Because obviously the district court's opinion was not the rationale given in the Fourth Circuit, but how do we draw that line? Because many, maybe not every, but many refusal to acts can be recast, if you would, as actions, right? They're, terminate or accommodate. Or in many ways, two sides of the same coin. Is it solely limited in your view to the manner in which the plaintiff pled his claim? That doesn't seem consistent with the way we think about removal generally.
No, Your Honor, it's not. But I think when you look at the context of the statute, I think our reading is appropriate. And the context is that it's to provide a federal venue for a state official who doesn't want to enforce a state law that they believe is contrary to federal law, right? Well, in this case, that's not even the situation. The defendants are actually arguing that Virginia Human Rights Act also compels them to act exactly like the Title IX Act. There is no conflict there. They're acting pursuant to the Virginia law as well. That's what they're arguing in the state court at this time. And so when you're looking at a refusal to act, they didn't refuse to enforce any state law. In fact, they say that they were compelled by state law to do that. And that's exactly
the flip side of that, right, is that they refused, so the argument goes, that they refused to enforce RFRA, and the Virginia RFRA, and that the reason they refused to enforce the Virginia RFRA was because it violated Title IX, or some version, that's a shorthand version of that argument. So help me understand why we wouldn't think of that as a refusal to enforce the Virginia RFRA.
So if you think about this, when the accommodation came up, the accommodation request from Mr. Blaming only came up when they enforced the policy against him, that enforcement. The accommodation request, because he was acting as he had always done. He was referring to students as he always has, and then they enforced the policy. That's when the request came up, and they said, we're going to terminate you. So that's the action. And the refusal clause again, is when they refuse to enforce a state law, which they indicate is contrary to federal law, and that's really not even applicable here. But every one of Mr. Blaming's actions, every one of the causes of actions, all 9 of them, are based upon the damages that he suffered from the termination themselves. And there wouldn't have been a...
One other issue, just kind of, at least from my standpoint, rounding out the elements of the second part of subsection 2. Do you dispute that the school board are state officials?
I don't. I think that they would be considered state officials if they consistent that they were enforcing a state law. Correct. Yes, I don't dispute that.
Okay.
But I think,
make sure I understand that. What you're saying is that they are state officials, and they could be enforcing. If they were enforcing a state law, they would be state officials. But to the extent they're not, then. But so the difference for you is whether they're enforcing a state law or not.
I think that's accurate, Your Honor, because again, I think in order to qualify, essentially they have to say they refused to enforce a state, a state law, and they don't. That's not the claims here. The claims that they're trying to remove are the act of terminating, and again, the other issue you have to recognize here is that this is a municipality, and so they can only act if state law gives them the right to act. That's the Dillon rule claim. They can't act otherwise. So I think that
Mr. Langhofer, let me ask you. Tell me what you think the distinction between enforcement and compliance is.
Well, I think a compliance would be there's a law that everybody is required to abide by, but enforcement would be the specific granting of authority by some governmental official to maybe another governmental official to actually enforce the policy itself. And I think that when you look at the language that Greenwood used, it's very specific. It says it has to be a federal officer or that agent authorized to enforce a specific act. And then again, when you look at every case that they cite, Bolander, Burns, and Linker, every one of the school boards were specifically acting at the order of a court or a federal agency. And so that's the distinction that I think is really key here, is that the first clause is very limited under Greenwood to federal officers or agents acting at the specific direction, if you're not a federal officer, you have to be an agent acting at the direction of a federal officer, like a district court or a federal agency. And I think as my friend on the other side indicated, they were essentially, there was no specific direction given. They were just kind of interpreting what they thought Title IX was and acting accordingly. And that's not sufficient under Greenwood or our Supreme Court's jurisprudence. So again, when you look at all of the case law, we have that their claims are prohibited under the fact that 1443 is limited to laws governing racial equality. You also have the fact that they are not federal officers or agents under federal law. Under the first clause of Section 1443. And further, they did not refuse to take any act, and thus they don't qualify under the second clause of 1443. And what we're dealing with here, really is a completely state law action, and the district court properly ruled that Section 1443 does not confer jurisdiction in that situation. No court has ever allowed removal outside the race context, and ruling otherwise here would create a circuit split. Since the defendants are not the federal officers under the first clause, and they didn't refuse to act as required by the second clause, they do not qualify under Section 1443. And as my friend on the other side indicated, under 1441, this court does not have jurisdiction to review that. So what the defendants are really asking this court to do is to hold that the federal courts are the proper venue to decide, these purely state law claims. And if you think about it, if you took their reading, it would really open up the floodgate for every case in which a state constitution looked to federal constitutions for rulings, or in even state employment law claims where somebody claims that they're required by Title VII to take this action. Under their theory, they could remove those purely state employment law claims to federal court. That's not the proper reading of 1443. It's not consistent with the Supreme Court's ruling or any of the subsequent rulings from any of the other courts. These are quintessential state law claims. Mr. Blaming brought only state law claims, and the defendants do not qualify under Section 1443. So we respectfully ask that this court to affirm the district court.
All right, thank you, sir. Mr. Williams, you have some rebuttal time.
Yes, Your Honor, thank you. We must begin by accepting that we must give effect to Congress's pronouncements. Of course, in 1866, when the Civil Rights Act predecessor to Section 1443(2) was drafted, Congress could not have intended that in 1875, necessarily that language would be extended, that in 1966, the Supreme Court would then adopt a limiting principle that was not a part of the text, and then that rule would bar this suit from coming to federal court in protection of a transgender student's rights under the federal Title IX Act. My friend on the other side has conceded to this court that Rachel does not compel the outcome as with respect to the equal reading the law under equal rights as limiting itself solely to race. And I'd like to address on the refusal clause prong the common cause cases, which are the most recent discussions of the refusal clause. The West Point School Board was first in the Fourth Circuit. The reason that the legislative defendants did not qualify for the refusal clause because this court reasoned that they did not have enforcement authority. Of course, in a footnote in common cause, this court acknowledges that school boards are the type of quasi-legislative entities that also have enforcement authority, and so therefore would not be barred from the refusal clause.
So, but to go back to your point and to return to the idea about enforcement, your response to Judge Floyd and my question about enforcement was to say, well, it just says act, and so we don't need to look to enforcement. But common cause seems to tell us pretty strongly that act is limited to enforcement. And that's the basis of the common cause ruling.
That's right, Your Honor.
I understand they're different entities, but the holding there is that they lack enforcement, and without enforcement, they couldn't be under Clause 2.
That's right, Your Honor. But the school board does act under Title IX. It takes actions under that are consistent with, and it's obligated by Title IX to rid itself, its educational programs, of discrimination on the basis of sex. That is the command of Title IX.
So can I follow up on that? So in the related 1442 removal, the Supreme Court in Watson draws a pretty strong line between compliance with federal law and acting to enforce federal law. And there says even highly regulated, very supervised areas like tobacco, merely acting in compliance with is not sufficient. Why doesn't that case sort of dictate this, compliance, acting to enforce distinction?
I think that the historical record around Section 1443(2) is informative. And I may take a few minutes past my time, Your Honor, if you don't mind. So the Freedmen's-Bureau and federal officers under the Freedmen's-Bureau were the first federal officers contemplated for use under the predecessor of Section 1443(2). This court says in Baines, and also the Supreme Court says in City of Greenwood, that the progenitors of Section 1443(2) anticipated that thousands of people, not just the federal officers, not just the commissioners, but also bystanders who were asked to take actions consistent with the Freedmen's Bureau Act at the time, 1865, would be able to bring removal or remove their case to federal court. And so this is the type of cooperative relationship between school boards and the Department of Education Office of Civil Rights that are similar to the types of relationships between the Freedmen's Bureau and its second, third level down officials or enforcers, people who would take actions consistent with their pronouncements. The Department of Education Office of Civil Rights could, if John Doe here had filed a complaint with the Department of Education Office of Civil Rights, compelled the West Point School Board to take an action. And the school board did not have to wait, Your Honor, we submit, for that to occur in order to take action consistent with Title IX. Your Honor, we are out of time, but we would submit to this court that the district court got it wrong on the question of removal jurisdiction. One, because 1443.2's plain text compels a different outcome, and because, Your Honors, Rachel is not conclusory on the question of what is a law providing for equal rights. Thank you so much for your time.
All right, thank you, gentlemen. As you know, this is being done virtually. Ordinarily, if we were in Richmond, we'd come down and shake your hand and tell you what a good job you did. But let me just say, you both did a really good job in a very interesting case. And so take a virtual handshake from us. Thank you very much. All right, going to our second case, United States of America versus Narang. I'm going to take a shot at this and tell me if I'm wrong. Mr. Kayonaga, is that the way you pronounce your name?
Kayonaga, Your Honor.
All right, thank you, sir. And then Mr. Hanley. All right, you may proceed, Mr. Kayonaga.
Please support John Kayonaga for Rita Narang. Ms. Narang was tried without indictment, without any regulation recognizably prescribing the behavior that she was convicted, but to the elements. Ms. Narang was indicted for being and subsequently.
Counsel, I'm having trouble hearing you. Can you get closer to your microphone?
Yes, sir. I'm sorry. Can the court hear me now?
Better.
Yeah, that's good.
Yeah, stay up there. That's much better. But yeah, that's great.
I'm going to try to kick this back so you can see my head. Ms. Narang was indicted for visa fraud. She subsequently pled guilty to a replacement information for wire fraud, cooperated with the government. The government issued a superseding indictment. The grand jury, at the government's behest, issued a superseding indictment against two of Ms. Narang's co-defendants. The superseding indictment did not include Ms. Narang. The case against under the superseding indictment was dismissed after a discovery of a Brady violation, consequent to which Ms. Narang allowed to withdraw her plea. She eventually withdrew her plea to the information. Some 10 weeks later, she was tried on the indictment. At the time of her trial, there had been no appeal of the dismissal of the indictment. There had been no motion to reinstate the indictment, and there had been no order to reinstate the indictment. Ms. Narang was a mid-level manager for Ecomnets, a staffing company owned by Raj Kasuri, dedicated to the business of recruiting workers from India for end users in the industry. This was known as third-party contracting, wherein the people petitioning for the H-1B visa were not the people who ultimately would have the workers sitting in their facilities doing their work. And because the government was hostile to third-party contracting, they charged the members of the Kasuri companies to include Ms. Narang. Specific misconduct, which the government alleged, comprised the use of shell companies, companies wholly Court, hear me? Can the court hear me?
We can now.
Well, you froze up.
Hello?
You're not there right now.
In any event, the use of shell companies, the use of fictitious names in signing the petitions, petitioning for speculative positions, touting Danville, Virginia as the locus of the work to be performed, when in fact there was no work to be done at Danville, and benching, the practice of not paying visa beneficiaries until they were actually hired and working. These were all earmarks of the practice known as third-party contracting. The jury. The grand jury belongs to no branch of the government. In fact, it is functionally independent of the government for the specific purpose of serving as a buffer between individuals and courts and the executive branch. At the time of Ms. Narang's trial, the indictment had been dismissed. It had not.
No.
Oh, man.
It,
Mr. Kiyonaga, do you have your phone with you?
Yes, I'm going to.
We're going to try to join you by phone so your audio can be on the over the phone.
Okay.
Thank you.
Sure. Are you just going to call me?
Thank you.
I'm terribly sorry. I had an issue with the internet, with my computer in the office, so I came over to Mr. Reed's, and I guess the conference room doesn't have good internet. I didn't expect this.
that's fine. You can proceed. The clock stopped, so you're good to go.
I didn't mean to blame that on Mr. Reed. Any good work done in this case is his responsibility.
Yeah.
Any of that. Thank you, Your Honors. At the time of Ms. Narang's trial, the indictment had been dismissed. The dismissal had never been appealed. There had been no motion for reinstatement, no order for reinstatement. As a practical matter, the indictment was absolutely beyond the reach of the government and the court. A court cannot assume that one grand jury is going to behave the same way as another, and that's particularly
important in this case, where the trial court found the government's conduct before the grand jury that issued the only indictment shocking and extraordinary by virtue of the way they led the witnesses.
Counsel, counsel.
Yes, sir.
This is Judge Richardson. Can you just take a minute on the order piece of this? I understand there are a number of different pieces, but on what you claim is a lack of an order, and respond. We recently, in a case called Soloff, said that the failure to explicitly accept a plea agreement, we would deem that to be accepted where it was implicit. And so it seems here, I'd love for you to tell me why that principle should not equally apply here, given that setting trial and all the actions taken were quite implicitly clear that the indictment had been reinstated. Why is the Soloff decision not applicable here, in your view?
Several reasons, Your Honor. First of all, in order to reinstate an indictment, the government needed to follow Section 3296 and move the reinstatement within the jurisdictional 60-day period following the withdrawal of the plea to the
all right, let's just assume that was done and focus on the order question.
Well, Your Honor, in order for there to be an order, there has to be, in effect, an order. The only statement the trial court made on the issue was prior to the withdrawal of Ms. Narang's guilty plea to the information outside the jurisdictional window for filing a motion accorded by Section 3296. She made a prospective statement about her intent should Ms. Narang elect to withdraw her plea. 2 weeks later, Ms. Narang did in fact withdraw her plea.
Why is that different from Soloff? That's what I'm trying to get at. And maybe there's not a distinction, but do you have a distinction from the rationale given in Soloff?
Yes, sir. The trial court did not have jurisdiction to reinstate the indictment. There had been no motion for a reinstatement of the indictment, and most particularly within the period allowed by 3296. That is a jurisdictional statute as per the Bowles decision, and the court has to conform its conduct to the requirements of that statute, just as the government had to. There was no motion to reinstate the indictment within the 60-day period under the statute. There was no motion at any time. Therefore, the court lacked jurisdiction unilaterally to reinstate the indictment. That's a very clear prescription.
Help me understand, just to make sure I'm understanding the argument. Your position is that the motion must be made after the withdrawal of the guilty plea, but I don't naturally read the language to say that. Why do I read within 60 days to mean, within 60 days after the order? There's no after in the statute that we have here. Why is it limited to after the withdrawal?
Your Honor, because I would submit that's inferring after is the only reading that would make any sense.
But we have lots of in the same U.S. code, we have a number of instances where it does say within a certain time period after, and we have other instances where it says a certain time period before, and then we say within a certain time period of, and the of seems to include both before and after. Why not?
Because 30 days after the court entered the order dismissing the indictment, the indictment was beyond the reach of the court and the government. It had essentially evaporated. The court did not have the jurisdiction unilaterally at that point to reinstate it. It required conformity with the requisites of 3296, and 3296 would make no sense if it accorded jurisdiction to the court before the operative event that created that jurisdiction, which had to be initially the withdrawal of the plea to the information and secondarily a government motion seeking the reinstatement.
Mr. Coyote, two questions. One, isn't jurisdiction predicated upon law, a violation against the laws of the United States first? And secondly, if that's true, the court had jurisdiction. Why can't we just treat this as a ministerial problem as opposed to jurisdictional?
Your Honor, first of all, the statute you're citing is a general statute for providing courts of jurisdiction over all criminal offenses in violation of the federal code. The statute that we're discussing is far more focused and therefore controlling, dealing with the issue of an indictment, when an indictment is alive and operative and when it is dead and irretrievably beyond the reach of the court and everyone else. Congress limited the court to 30 days from the dismissal to reconsider the dismissal of an indictment. Once those 30 days lapse, which they unquestionably did in this case, the indictment is gone. There is no way to bring it back.
What is the 30? I'm sorry. I want to make sure I'm following you. What is the 30 days? What statute is 30 days in?
Section 3731, Your Honor. The 30 days to appeal an order of a court.
So, in other words, you're saying the district court's jurisdiction turns on the existence of appellate jurisdiction? I'm not sure why 3731 has anything to do with the district court's jurisdiction.
Well, Your Honor, your question, I would submit, is intertwined with the unique position of the grand jury. The grand jury is uniquely and exclusively able to return an indictment. Once the indictment is dismissed by the district court, it becomes final after the expiration of 30 days, as per the operation of 3731. It cannot be restored, it cannot be resurrected unless there's an appeal or unless there's a withdrawal to a subsequent information, which would then implicate the requirements of 3296. The Congress did not envision perpetual indictments floating around in the ether, ready for the judge or the government to resurrect them at will. The court's jurisdiction over the indictment ended 30 days after the court entered its order dismissing the indictment. There are only two orders pertaining to the indictment in this record: the return of the indictment from the grand jury and the dismissal of the indictment. That's it. And that deprived the court utterly of jurisdiction to try Ms. Narang under the indictment. They could have tried her under the information, but that's not what the government offered to do. The information was never dismissed. And the court even admitted, and I would direct you to Joint Appendix page 171, just prior to opining prospectively about her ability unilaterally to reinstate the indictment, she said, "I don't even know which charging document Ms. Narang has at this point." So I would submit to the court that it would be an error to infer from this process an undue amount of deliberation and purpose.
Counsel, this is Judge Quattlebaum. I have a question. Assume, just for discussion, that we disagree with you that 3296 is jurisdictional, and we believe it's procedural or ministerial. It seems as if that there's at least a pretty good argument your client didn't object, although I know you're not conceding that. But assume we're looking at this under plain error for a non-jurisdictional issue. What would be your position about how you satisfy the requirements of our plain error review?
Your Honor, first of all, the government has the burden on the review of a jurisdictional issue. But I would submit the government maintains that having raised the issue, Ms. Narang somehow waived it because she didn't further brief it. Any judge who sat as a trial judge knows that once a litigant makes his or her position known and it's rejected by the court, courts do not appreciate having it repeated. I raised the issue very, very clearly. I said without any ambiguity that if the government wants to proceed by indictment, is going to have to return to the grand jury for a new one. This was before Ms. Narang withdrew her plea to the information. The government essentially waived, if the court is seeking for the sake of argument to treat this as a non-jurisdictional question, then the government waived the ability to proceed under indictment by failing to move the reinstatement of the indictment. Would the court like me to continue? Can the court hear me?
Yes, sir.
Hello? Okay.
Yes, sir, we hear you.
May I continue, Your Honor?
Yes.
Yes. My fundamental point is this. The grand jury is uniquely positioned in the constitutional firmament as a buffer between individuals and the branches of government. There is no way to honor that purpose and that position by allowing an indictment to exist indefinitely. It dies once it's dismissed. If it's not restored by appeal, and it's not restored by a motion to reinstate, it is terminally, absolutely, and dispositively defunct. Now, 3731 is a jurisdictional statute. It allows 30 days to note the appeal. The Weaver decision of this court has said as much. The court never, the government never noted an appeal. As I said earlier, 3296 under Bowles is also jurisdiction. But the government's claim that it is not simply leaves it open to the fact that if it's not jurisdictional, they waived the right to proceed by indictment by not moving to reinstate. The court's order, its court's memorandum opinion was issued 21 months after the trial. And the court found in her order that she had reinstated prior to trial the indictment. She did not specify when, she did not specify how, because there is absolutely no reflection in the record of any order to reinstate the indictment. The only mention by the court of the indictment came prior to the withdrawal of Ms. Narang's plea in response to my having identified the issue and insisting that the government needed to return to the grand jury if it wanted to proceed by indictment. The court issued prospectively an opinion that, or a statement that she would unilaterally indict. The fact that she never followed up. I'm sorry, sir?
Mr. Kayanaga, your time has expired. You have some time in rebuttal.
Very well, Your Honor.
All right, Mr. Hanley.
May it please the court, I'm Jack Hanley. I represent the United States in this appeal. The statute 18 U.S.C. section 3296 is not a jurisdictional statute. It is not a statute that depends on the court's ability to preside over the case. Rather, can you hear me, Your Honors?
Yes.
Rather, it's a statute that decides how the court is supposed to exercise its authority under certain circumstances. The Supreme Court has cut back very much, and so has this court, on what's considered jurisdictional and what is not. There are a few things, though, that are pretty consistent in those cases. One of them is clear legislative purpose that the statute is to be jurisdictional. Doesn't have to be any magic words by Congress, but it has to be pretty clear. The second thing would be that the jurisdictional statutes determine whether the court can even preside over the case or the matter. In cases where the court is already presiding over the matter, already has jurisdiction over it, and there's a statute that tells the court how to exercise its authority, that's not a jurisdictional statute. The court already has a jurisdiction. Third thing that I've noted about these types of decisions is if something is jurisdictional, it's not waivable. Now, if we apply those principles here to this case, you read the statute, I submit that there is no clear congressional purpose in making this a jurisdictional statute. Secondly, and very important, this court already had jurisdiction over this indictment. This court had jurisdiction over this case well before the plea and then the dismissal of the counts and the reinstatement. The court was presiding over the case. And throughout the time period, there were always charges pending before the court. First, it was the indictment, then the information came, and then the court reinstated the indictment. This is clearly a claim processing rule, as they call it. It's not a jurisdictional statute. And third, if you look at the provisions of that statute, I think you can conclude, although I don't have a case to support it, those are waivable provisions. It's a jurisdictional statute, it can't be waived. But Supreme Court's Cotton case and this court's Hartwell case make it clear that even the requirement that there be a grand jury indictment for a prosecution of a felony can be waived. And in fact, it's done every day. Grand jury indictments are waived every day. I think with this statute, it's a claim processing statute, and that's the way the facts of this case should be analyzed. If you analyze the facts of this case, first, I suggest Mr. Kiyonaga is in error when he said there was no motion by the government. The government did not file a separate document titled motion. Perhaps the government, myself being the one, should have entitled the document motion in response to defendant's motion to dismiss indictment and motion to reinstate the indictment. I didn't do that, that's my error, but I don't think that's a fatal error. I believe that in the government's response filed on September 8th, 2017, to Mr. Kiyonaga's motion to dismiss the indictment, the government's final paragraph was the request that the court deny the motion to dismiss the indictment, allow Ms. Narang to withdraw her plea, reinstate the indictment, and set the matter for trial. The next hearing was September 22nd. Well, on August 11th, Mr. Kiyonaga brought up the fact that the government thought that the court could reinstate the indictment unilaterally. I believe that was based on a conversation that I'd had with him. It was not in a prior pleading. But by September 22nd, we had included that paragraph in the response to the motion to dismiss the indictment, asking that the indictment be reinstated after Ms. Narang withdrew her plea. And Judge Brinkema, on September 22nd, brought up the paragraph that the government had included. And she had already made known on August 11th that she believed that she could do that. She had said, Ms. Narang withdraws her plea, and I intend to reinstate the indictment. So we were operating with that background. And Judge Brinkema brought up the government's request for reinstatement, but she said, I'm not prepared to do that yet unless Ms. Narang has made her decision. And Mr. Kiyonaga said, Ms. Narang has made her decision. We want to withdraw the plea. Judge Brinkema said, all right. Well, at that point, all through that point, the government's motion and the government, we submit that the paragraph we put in the response to the motion to dismiss was a motion. That motion was pending. It didn't stop at the time of the motion. That motion was continuing to remain pending, throughout Mr. Kiyonaga's statement that Ms. Narang moves to withdraw the plea. And then Judge Brinkema said, all right. At that point, she was granting the motion. It could have been clearer, but all the parties knew what she was doing. Her act was just ministerial. She knew that she had to do it because the government had made the motion and Ms. Narang had elected to withdraw her plea. So Judge Brinkema says, all right. And then Mr. Kiyonaga immediately went into talking with the judge about setting a court date and what would be difficult for him for trial. And I believe I probably answered the judge's question about what would work for us. And then the judge held in abeyance the trial date and told us to talk about it more. But then Ms. Narang, at that point, waived her right to a jury trial. If they believed that the indictment was not pending, you would think they would have said something. They didn't. They waived the right to a jury trial. Mr. Kiyonaga at that time did not acknowledge that the trial would be to the indictment rather than the information, but subsequently he moved to dismiss the indictment. He did not say anything about the indictment hasn't been reinstated. He moved to dismiss it before the trial. He also moved to limit the government's evidence to only those overt acts of the conspiracy that had been alleged in the indictment, not to any additional acts. He said nothing then about there's no reinstated indictment. He moved again to dismiss the indictment after the trial. Again, he did not bring up the argument. Judge Brinkema issued her opinion as if the indictment had been reinstated, and she in fact said the indictment had been reinstated. Subsequently, more than 2 years after this, Mr. Kiyonaga filed a motion on behalf of the defendant with this court asking for bail. And in there, he said that the indictment had been reinstated. So in our view, that indictment, as everybody saw it, had been reinstated. And we agree with Judge Richardson's analysis. The Stoloff case situation certainly applies here. The court found in that case that the plea had been accepted, even though there weren't any magic words accepting the plea. In this case, there was nothing more for Judge Brinkema to say. She didn't have to justify interests of justice like in speedy trial or manifest necessity like in double jeopardy situation. All she had to do was say, indictment's reinstated. What she said was all right, but all the parties interpreted that as reinstating the indictment. I point particularly at the Mann case where this court has said, when it's not clear, you look at how the judge interpreted his or her own order. And in this case, Judge Brinkema clearly interpreted what she said, as did the parties at the time, that the indictment had been reinstated. And it's important that this is not a jurisdictional rule, because as a claim processing rule, it is subject to a plain error standard. Mr. Kiyonaga forfeited any argument that the indictment had not been reinstated. So it has to be analyzed in terms of plain error. He had objected early on, saying that I think there has to be a grand jury. But when Judge Brinkema said, we'll brief it if you want to, but I don't agree with you, I don't think, but go ahead and brief it, he chose not to do so. But that was the argument about whether there had to be a grand jury. And I think the Cotton and Hartwell cases make clear that it doesn't necessarily have to be a grand jury. There can be other ways to bring charges before the court, which is done all the time. And so here we have to look at, is there any plain error? And there is no plain error. There's no law out there that says Judge Brinkema had to give some magic words. There's no law out there that says the government's motion can't be in another pleading. It has to be in something specifically entitled motion. We think he's forfeited the error. If there is any, government submits there isn't any error. But if there was one, it was forfeited, and therefore it would have to be by plain error. And clearly here, it's not plain. There's no case law out there that would suggest in any way that the reinstatement of the indictment here was a plain error. And there's no prejudice to the defendant. Had he brought it up, the government could say, yes, Your Honor, we make a motion, and Judge Brinkema could have said, then I reinstate. That's really not necessary. But if he wanted to make the argument, he should have made the argument, and then it could easily have been corrected. And as the proceedings went, there's no harm to him. He had the same trial he would have if we followed those proceedings. And Ms. Narang had the same trial. She had the same rights. So in the government's opinion, everything was done properly here. Could have been done a little more clearly by both myself and by Judge Brinkema, but it's not so much that there's a plain error here. That's our argument on that point. Beyond that, Mr. Kiyonaga had made several arguments about the sufficiency of the evidence. Judge Brinkema was very thorough in her opinion. She focused, as the government did, on the false statements as to where the beneficiaries would be employed when they obtained their visas. That was a document, the H-1B petition, and included within that and required was the the LCA document. Both of them included the name and where the people would be employed. And the lies on there were clear. Mr. Kiyonaga brought up in his 28J letters certain concepts that he thought weren't clear in the regulations of ICE. And there was one opinion, IT Serve, in the U.S. District Court in D.C., where there was an argument not over whether the location and the actual job availability would be when the person got their visa. It was rather whether ICE could require, as they were at that time, that applicants submit where the job is going to be for the next 3 years. And that was what was invalidated. It was never invalidated that on their applications they had to put what the job would be, where it was, and who the employer was. So Judge Brinkman's opinion did talk about a number of things that showed there was fraud here. She talked about the benching, where people aren't working during certain periods of time. She talked about the ComNets and in particular the defendant requiring visa applicants who got their visas but didn't have any jobs sign voluntary leave petitions so that ComNets wouldn't have to pay them. She talked about the shell companies, which in and of themselves aren't a fraud. She showed how these shell companies made a difference and allowed the fraud scheme to proceed. So for the reasons that she stated, we believe that the case was more than sufficient and the conviction should stand. Mr. Kiyonaga had brought up in his brief advice of counsel, and he did not lay any kind of specifics out there that would have supported an advice of counsel defense. First of all, we don't even know whether Ms. Narang relied on anything or at all. There's no evidence of that. But he talked about a few issues. He said shell companies, counsel said, were legal. Well, the question is, were they told how the shell companies were being used? Well, that wasn't in the record. He talked about voluntary leave petitions. Were they legal? Again, counsel might have said they're legal, but there's no indication that counsel knew how that process was being used, all to support the fraud as opposed to anything else. And the third thing he said was that Mr. Kasuri, who's the owner of ComNets and testified for the government, said, and I think Ms. Coward did as well, everybody at the facility knew that there were no jobs at Danville, that was false. Mr. Kiyonaga asked, well, did Mr. Chaco know about that? And he was one of the lawyers. And Mr. Kasuri said yes. Mr. Chaco may have known about it at some point. I would submit exhibits 47 and 48 show he didn't apparently know about it in 2013. He was acting as if everything was above board. 2014, in an email to Ms. Narang, he was warning her about leaving a ComNet's names off the leases, that she should have left them off the leases for the shell company. So at that time, he probably knew. But Mr. Kiyonaga did not follow up. There's no indication when Mr. Chaco knew that there was some kind of fraud going on. There's no indication whether it was his advice that was given to Ms. Narang, or there was the advice of the other lawyers who apparently didn't know that there was no jobs at Danville. So their advice would have been accurate if there had been places open at Danville. So those are the arguments that I want to address. If this court has any questions, I'll be happy to answer them. Otherwise, I'll stop at this point.
I think they're indicating we don't have any questions. Thank you very much for your argument. Mr. Kiyonaga, you have 5 minutes in rebuttal time.
Thank you, Your Honor. The government had the burden to reinstate the indictment. It erred by failing to do so. If the requirements of 3296 are not jurisdictional, the government has admitted they did not file a motion to reinstate, and the issue has been waived, and the indictment was forfeit. I would ask the court to consider how 3296 can be considered not jurisdictional if it is the only means by which a court can reinstate an indictment which has been dismissed and for which the appeal period is passed. The grand jury is a separate entity with a power that the court, frankly, cannot touch. This window into creating an ability for the court to do so is clearly jurisdictional. The government's position that it is not essentially admits a waiver that resolves the issue in any of that. But the government misstates that the court already had jurisdiction, and it disappeared with the expiration of 30 days after the dismissal. The government also mentioned benching, although I read the government's 28J to concede that benching was not material to the trial court's order and not to be considered today. There is no question but that 3296 was jurisdictional. It provided a very, very consequential, that is to say limited, jurisdiction for the court to restore, i.e. reinstate, an action that was outside of its control. The government enacted in 2018 Policy Memorandum 602-1057. I'll call it the Policy Memorandum. This is addressing exactly the supposed misdeeds by the Kasuri companies. The D.C. District Court last year rejected the Policy Memorandum in its entirety as inconsistent with statutes and law, as arbitrary and capricious, as vague. In fact, it said it upends a business model, i.e. third-party contracting, without congressional sanction. The court should note that the government was keenly aware of the unenforceability of its regulatory regimen governing H-1B petitions as early as April of 2017. They acknowledged to the D.C. court that they began to review, or they acknowledged in a publication with a later regulation that they began to review their regulations with an eye to clarifying them. It bears noting that the government never shared these doubts that they had about their own regulations with Ms. Narang, although they started reviewing the regs 7 months before trying her with the trial court or with this court. A law that cannot be understood is a law that cannot create mens rea. That's by the malice decision out of this court. The trial court committed 2 very, very grievous errors in reviewing the evidence. In order to prove visa fraud, the government had to prove materiality, a sworn statement, and mens rea. Materiality was forfeit from the beginning because almost everything that the Kasuri companies did was either not prescribed by regulation or statute or affirmatively allowed. Shell companies, they could point to no regulation forbidding it, and the government's own expert, Mr. Violet, admitted that intermediaries are common in the petition process. Fictitious names, no regulation forbids it. As long as it binds the company, it's fine, also from Mr. Violet. More importantly, the regulations call for petitions to be signed by human resource managers, and they specifically allow anglicized names for the signatures. The Kasuri human resource manager was Sanchita Bhattacharya. The 2 pseudonymous names were Sonia Basu and Sam Bose, clearly anglicized versions. Prospective employment was also not forbidden. In fact, the regulation precluded petitions for positions that would not become available until more than 6 months had elapsed. So the regulations themselves envisioned prospective applications, and Mr. Violet admitted as much. The only other 2 items of misconduct, quote unquote, were the practice of reflecting Danville as a locus of work and the practice of benching. Benching is off the table, as per the government's own concession. Danville the location was a matter exclusively within the control and the purview of the Department of Labor. Under the The Razor case of this circuit, a fraud against the government, has to be proven by demonstrating the materiality of the misstatement to the agency or individuals to whom it was targeted. Absolutely nobody from the Department of Labor testified.
Mr. Kayanaga, your time has expired, so we thank you very much for your argument. And to both of you, ordinarily we would come down and shake your hand, and unfortunately, virtually, we can't do that. So just take a virtual handshake from us. So thank you very much for your arguments today.
Thank you, Your Honor.
Is in the last case today, and is it pronounced Mr. Giuliani? You're muted.
I apologize, Your Honor. It's Guillaume.
Oh, Guillaume. Oh, I'm sorry. I tried to take a stab at it and I missed it. So we're glad to have you here today, and you may proceed.
Thank you, Your Honors. Good afternoon. May it please this honorable court. My name is Alfred Guillaume. I'm counsel for appellant Maximo Gondres Medrano. Your Honors, in this case, the district court erred when it determined that the search of Mr. Gondres Medrano's shoebox was lawful. Also at trial, the district court abused its discretion by admitting a video self-reported by Mr. Gondres Medrano, which confused the members of the jury. Lastly, the district court improperly imposed an obstruction of justice enhancement at sentencing. Your Honors, beginning first with the motion to suppress, it is our position that an uncorroborated informant's tip received by the police in this case that Mr. Gondres Medrano was going to be involved in a drug deal on a specific date did not establish probable cause to search a shoebox he was carrying on that date. The search of the shoebox was also not supported by any other exception to the warrant requirement of the Fourth Amendment. In particular, the search incident to arrest exception and the automobile exception. Your Honors, this case involves Mr. Gondres Medrano, who police began investigating in the summer of 2017, approximately 2 to 3 months prior to searching his shoebox. The initial tip by the informant was that Mr. Gondres Medrano was a drug dealer transporting drugs between New York and Baltimore. The lead detective on the case had never before arrested Mr. Gondres Medrano. He'd never seen him before. He never heard his voice before. And the lead investigator, Mr. Gondres Medrano, is of Dominican descent. The lead investigator does not speak or understand Spanish. From the initial investigation, which began around July 2017, the police ended up obtaining a tracking warrant for Mr. Gondres Medrano's vehicle. That tracking warrant, the warrant for the tracking device on the vehicle yielded no information, in other words, did not corroborate the informant's tip that Mr. Gondres Medrano was in fact a drug dealer moving.
Counsel, what was the tracking warrant based on? What was the probable cause for the tracking warrant? Wasn't it the informant statements?
Yes, Your Honor. The probable cause was a couple of things. One, that Mr. Gondres Medrano was in fact transporting drugs, and that the informant had worked with him before, and also, Your Honor, that I believe a phone call at issue in the case where the informant was present, the detective was present, and a translator from the FBI, or excuse me, I can't remember the agency, but a translator was present there as well. And the basis of that call, the conversation was allegedly about narcotics. But again, I would just remind the court that not even disputing that the call may have been about narcotics, is that the person's voice on the other end of that phone was unknown to the officers at the time. So we would submit that it may have been enough for the tracking warrant, but it still does not establish probable cause for the eventual search of Mr. Gondres Medrano.
Counsel, to follow up on that, at the time, if it was enough for the tracking warrant, didn't the warrant reveal information about the location that was consistent with what was heard on from the informant?
Your Honor, I don't know if I understand the question, but the location of the search, are you referring to the eventual search?
No, I mean, didn't it indicate the location of the home from which the search was going to, or from which your client was going to leave?
Your Honor, the warrant was able to confirm that Mr. Gondres Medrano lived in the particular home that has been alleged here, but the investigation was going on prior to the actual concrete tip that the informant gave the officers. So Mr. Gondres Medrano, in fact, during the motions hearing or trial, the officers said that the only thing that was able to be confirmed at the time, well, that's my way of putting it, the only thing that was able to be confirmed was that fact that he did live at that address, but there was no other indication that anything illegal was happening at that address, any sort of drug activity. Your Honor, I just point the court to the Wilhelm case in which this court did not uphold the search of a home where the informant told the police that she had personally observed drugs in the home and drugs being sold from the home. And just to piggyback on what I just said a moment ago, Mr. Gondres Medrano's residence was confirmed, but never any kind of illegal activity attributed to that residence. In this case, Your Honor, the 3 months leading up to his eventual search of his personal property yielded no confirmation of that initial informant's tip. I point to the cases of Blackwood and Miller. In both those cases, there was something that corroborated the informant's information. In Blackwood, there was a controlled buy. The officers were standing right outside. The information received in both cases was similar to this case, that this person is a suspected drug dealer. And in Blackwood, the informant actually purchased drugs, and then the officer obtained a warrant to search. In Miller, the officer had actually previously arrested the defendant recently, and also received the tip that the defendant in that case was going to be wearing specific clothing and traveling from a location on a certain date. And the officer arrived to the location, saw the person, knew them, and also the objects that they were carrying gave some sort of indicia of potential packaging of drugs. We don't have that in this case, Your Honors. Mr. Medrano does have a prior criminal conviction, as the government has noted in its brief. However, the conviction was occurred from at the time of the case. It was a 2010 conviction, so that was 7 years old, and the case originated from 2005 out of New Jersey. So the officer was not involved and did not have any particular knowledge about that specific case. The government has also argued that exceptions apply to the search of Mr. Gondres Medrano's shoebox, in particular, the search incident to arrest exception. It's undisputed that the arrest of Mr. Gondres Medrano was for an immigration offense. We don't dispute that. However, under Gantt, the search of Mr. Gondres Medrano's box, must be relevant to the crime of his arrest, which is an immigration offense. So there's nothing to suggest that they should, under Gantt, they should search Mr. Gondres Medrano's shoebox. In fact, he's actually handcuffed, not near the car. He's not within reaching distance of the car, and it's not reasonable for an officer in that situation to believe that there's evidence of an immigration offense. And that kind of segues into the automobile exceptions, Your Honors, is that Mr. Gondres Medrano, when he's arrested, he's handcuffed. There's no contraband in plain view in the car. He doesn't attempt to hide anything. He doesn't attempt to run. He doesn't attempt to destroy evidence. In other words, there's no probable cause that exists, that develops during the stop in this case. Now, the government has cited a number of Supreme Court cases, and I believe a few Fourth Circuit cases as well, where the automobile exception was applicable but in every case that they cite, there was certain factors that caused probable cause to develop during the stop. We don't have that here. We just simply have an informant telling the police that he believes that without any further information, he's going to be transferring drugs that day. My client's going to be transporting drugs that day. And Your Honor, this court has stated, and I'm not sure if I'm pronouncing the name correctly, but the Pataiku case, the Paitutka case, that even if an officer has, with respect to the automobile exception, has reasonable suspicion to believe that there's potentially contraband in a vehicle, that's not enough, that you need more than that. And that's exactly what we have here, Your Honor. Even if it was, the officers believed it, the fact of the matter is they did not have enough probable cause nor any exceptions to search Mr. Gondres-Medrano's shoebox. Your Honor, if I could pivot to the abuse of discretion argument with respect to the video that was admitted at trial, we would argue that the district court did abuse its discretion by admitting the video because of the potential for juror confusion in this case. In the video, Mr. Gondres-Medrano is shown opening up what the government argues, and my client later testified to, was a bag of narcotics. However, the issue that caused the most amount of confusion was that, in fact, the government, in its opening argument, argued that the drugs in the the drugs in the envelope were the same drugs as the drugs in the that were eventually recovered. And we argue that that places our client, first of all, it's not really relevant, but it places our client in a difficult position. My client ultimately did testify. He gave an explanation for his actions in that case, in which he actually did not deny any criminal behavior. But the fact that a jury hears that and then hears the government saying that these are the same drugs, when he gave a very detailed accounting of what was in that envelope and where it came from, et cetera, and what he did with it afterwards, is very different from what ended up being the theory for our case in this particular item, that he actually stored drugs for a friend in his apartment. And to just add to that argument, Your Honor, is that with respect to that video admission, I did request that it be excluded prior to trial. It was denied. I asked for a curative instruction. The judge agreed at the time, and I, Your Honor, must admit that I did not ask again at the appropriate time for that instruction. But I do think that the damage that was done as a result of the video, even under a plain error analysis, looking at the Mitchell case, the factors in the Mitchell case that this court has laid out, still is instructive as to why it requires reversal. The admission of that video requires reversal. And Your Honor, if I could pivot last to the last argument that I have with respect to the sentencing enhancement that my client received. I will agree at the outset with the government's position that it was I guess the term used is substantively reasonable. It was only one more month added to the mandatory minimum sentence with respect to my client. However, I would argue that the district court's analysis of the perjury that was allegedly committed by Mr. Gondres-Medrano was in fact incorrect, focusing primarily on two factors, which were the contents of the envelope, which were not, again, which may or may not have been the drugs in this particular case, but our position was they were not, and whether he intended to show the video to police. I think that second argument overlooks the obvious that Mr. showed the video to the police voluntarily, albeit that his the timing was not in line with what the government's theory was. But that, even assuming that that's true, that he didn't intend to show it, we don't concede that, it's not material. Both things that I just mentioned are not material matters.
Well, Mr. In your best argument on that enhancement, probably that the judge didn't make a finding of willfulness, isn't that your best argument?
I think, additionally, Your Honor, I think it's a strong argument on both fronts, but it wasn't willful. Things weren't material, and I was point this court to the Perez case, which I cited in my brief, which the court found that the defendant in that case wasn't credible, but nonetheless wasn't for material matter. I see my time is expiring. I would like to reserve some.
Yes, you have some time in rebuttal. Mr. Hahn.
Good afternoon, Your Honor. May it please the court, Your Honors. My name is Jeffrey Hann. I represent the United States in this case. And the center point of this case was possession with intent to distribute this drugs inside this silver.
Counsel, if you could speak up a little bit, I'm having a little trouble hearing you. Maybe get a little closer and speak up. That'd be great.
Sure. Perhaps I'll take my headphones off. That might.
That's better there.
Can you hear me better at this point?
I think so.
All right. Your Honor, the center point of this case was this silver gray shoebox, which had a duct tape wrapped package of heroin mixed with fentanyl inside of it. The central question from the beginning of the trial through suppression arguments and the trial itself, and then ultimately sentencing, was who knew what was in that box, and how do we know that they knew it? How did the officers build probable cause to know that there was drug evidence in that box when they seized it? And then once they seized it and found that it contained drugs, what evidence is there to show that the defendant knew the nature of those drugs and intended to distribute them? That's what all the arguments here come back to. Turning first to the probable cause and the suppression issue, there was multiple axes of probable cause here. Obviously, there was probable cause to stop the defendant based on this immigration warrant. But separate from that, there was probable cause related to drug trafficking. This was not an anonymous tip. They had probable cause to believe that this day there was going to be drugs transported and that they were going to be inside that car ultimately based on their observations. So they had probable cause to believe the car contained evidence of a crime or contraband, to search it under the Carroll Doctrine. And because of what they observed, they had probable cause to believe the defendant was engaged in drug trafficking and that he was possessing drugs with intent to distribute. And so they had probable cause to arrest him, to search him incident to arrest, and ultimately to search the wingspan reach into that car. So there's two different bases for probable cause. Both of those stem from this source information. This is not an anonymous tip. This is not an uncorroborated tip, but rather it was information that Officer Williams got from a person he knows, an informant that he worked with over several months in 2017. That he testified that he had successfully gotten information from that led to successful arrests. So we know this is a reliable person. And he directly spoke to it, as distinguished from the Wilhelm case, where the officers there never got to speak to that tipster, and they never have any information about how the tipster had their information. Officer Williams directly was speaking to his source. And they used police work to corroborate the facts they were getting from him, even if those were innocent facts at first, the biographical information. They had a full name of the defendant. They knew his full identity and were able to start researching him. And they had an address where he lived, which was this 807 White Lock apartment. Officer Williams reached out to Homeland Security investigator Edward Kelly and started looking into the immigration history of the defendant. And that was corroborative. They found this immigration history that involved an overstay of a visa and ultimately led to that warrant, but also that he had these prior drug convictions. Now, obviously, Officer Williams wasn't involved in those drug convictions, but they existed, and they corroborate the information the informant was getting, that this is a guy who is engaged in drug trafficking. The arrest in 2005 for possession of intent to distribute in New Jersey that ultimately attributed to a conviction in 2010 for loitering to obtain or sell CBS. That is a drug conviction. Obviously, there's a gap in time there, but it was corroborative of the confidential informant. It shows his reliability. And then the physical location, this 807 White Lock address. That's important because we know that the defendant ultimately is seen there and that this is where he lives. And Officer Williams was conducting a drug investigation. He actually listened to the confidential informant make phone calls, albeit they were in Spanish, but he had a translator there to help him. This gives him a way to know that the informant knows what he's talking about. He has a basis for his tips. He has a reason to know that the defendant's engaged in drug trafficking because he's talking to him. He's calling this phone number, and in two separate calls, one on June 27th of 2017, and then again in July. The first call, the defendant is talking about going to New York, and he'll get cocaine, and he'll have that cocaine available if the confidential informant wants it. And then in June, he's again saying that he processes cocaine or drugs on behalf of a source that's in New York. And based on that, they wrote an affidavit to get location data. It was actually not a vehicle tracker in this case. It was location data from the cell phone that was being called by the confidential informant. And that corroborated the confidential informant because the ping data showed this 807 White Lock address is where this phone call is, this call is. Obviously, Officer Williams at that time doesn't know the voice of the defendant, Mr. Gondres Medrano, but now he knows the person that's being called lives in the address where his informant says he's going to be. All of those things are corroborative of this reliable informant. Then we get to September 8th of 2017. This is where the officers are actually going to watch with their own eyes, as in the Miller case and as in the Blackwood case, to things that the informant says are going to happen. The informant tells them on that particular day, at a specific time in the morning, the defendant is going to have heroin that he's going to bring from that apartment out of his house to broker a heroin deal. And so they do essentially what happens in the Blackwood case, this controlled buy operation. It's similar to that. They begin first investigating their confidential informant's person. They meet with him in the morning, search to make sure that he or she doesn't have drugs on them. They search the car to make sure that there's not drugs brought in the car. And then they watch through surveillance as this car is driven to the right address. And the confidential informant goes into the house, is there for about 2 to 3 minutes as Officer Williams testifies, and walks out just as expected. So this is observations that they're seeing that corroborate the tip that they've gotten from their reliable informant. And based on that, they now have probable cause to know that this drug deal is happening, that this shoebox that's being carried by Mr. Gonzo Medrano is drug evidence, and here it is going into a car, a readily mobile car. They watch him put it in the backseat. So they stop the car. They already have the immigration warrant. This again, when they identify him, corroborates that they've got the right person. And Officer Williams testifies, he looks into that backseat window and he sees the box is still in there. At the same point in time, Officer Kelly is on scene as well and secures the defendant. Both of them testify, both at the suppression motion and at the trial, that Mr. Gonzo Medrano is becoming agitated, I think they say howling, as this box is being recovered, that they ultimately find contains the content. Yeah.
Counsel, if I could ask a question, you just referred to testimony at the trial. Mm-hmm. Can testimony at the trial be, considered as to whether, in terms of the the court's decision on the motion to suppress?
Well, it can, Your Honor, because these are facts that are testified to that the court ultimately had to find. Now we got more detail.
But if they, but the decision had already been made. What's the basis for considering? Now, if they're the same facts, it's kind of six one hand, half dozen another. So that may not be an issue. But if they're different facts at trial, are those proper for consideration?
Well, here, Your Honor, the standard review is to examine the findings of facts by the judge for clear error, but the legal determination of is there probable cause, de novo, essentially. And so these are facts that you can find in the record that added to that probable cause. These are things that Officer Williams saw at that moment that built into the probable cause. It's true that detail wasn't as clear at the suppression motion as it was later, but it's a fact that existed in the real world that built the probable cause. This is something Officer Williams saw that went into his decision to search that box. And ultimately, there was probable cause because of the totality of circumstances that he's seen. So he has now reason to know and reason to believe that the car contains this box, which the informant has told them is a drug delivery. And they have now watched the defendant carry the box. So they know he's possessing with intent to distribute whatever's in this box, and he's part of this drug transaction that's happened. And so based on that, they have the right to search him, pursuant to Belton and Schimmel, search him in arrest and Gant, and his wingspan, the area he can reach inside of this car. And at the point that they recover that box, he's still next to the car. This is not Gant. He's not handcuffed on the curb, put in the back of a car, and then they search the car. These things are happening right on top of each other, with a defendant who is still agitated and is howling, and is handcuffed because of that reaction. So he still has access to this car, and there's still evidence of the crime of possession with intent to distribute in the car, independent of whether there's anything to be gained as far as immigration issues. So based on that, there's two different accesses of probable cause to this box specifically. And the court was correct to allow the box into evidence and to not suppress it. So then the next question at issue for this appeal is, what did the defendant know about what was in that box? And the video from his cell phone, the DHL video, is part of that evidence. It's probative of the key elements of possession with intent to distribute. Not just did he possess the shoebox, but did he knowingly possess it with knowledge of the contraband nature of what was inside the box with the intent to distribute it. And this DHL video of him opening a drug package covered from his phone was directly probative of those things. I point in my brief to the Samad case, which is kind of comparable, where a box is delivered to a house. The officers know it contains drugs because it's a controlled delivery, but there's no testimony developed that the defendant opens the box, that the defendant says anything to say he knows what's in the box, and they don't find things in the house that are like contraband evidence that he's engaged in drug trafficking, aside from bulk cash, essentially. Our case is different. The defendant confesses. He gives a lengthy recorded statement about this box and where it came from, and he tells us the relevance of this video. He says, translated of course into English, when they ask him, how did this box get to you? Essentially, this is it. This is how it got to me. Let me show you on my phone how it got here. And he plays this video for the officers. They then ultimately recover it from his phone when they search the phone with his consent. So that tells us that this video of what's happening on the phone is linked to the transaction that's happening on September 8th, and that he knows the nature of drugs, these kind of drugs specifically. He is asked what this is in the video. He says heroin. The box is heroin, and we later know mixed with fentanyl. And he knows the specific weight of it, 333 grams. And visible in the video is one of these tools of the trade for drug trafficking, a digital scale. So that's how, presumably, he knows the weight of the package. And this, therefore, shows that he has the knowledge of the contraband nature of what's inside that box, and that he intends
to. What was the explanation, if any, given to get from 333 to the 792 that you put on at trial?
We did not present sort of a theory of how the actual stuff in the DHL package related to the September 8th video. There was testimony that ultimately was developed. He said he actually brought that pack of drugs up to New York, that this stuff in the box was a separate drug.
That was his testimony at trial.
Exactly. And we don't know the truth of how that processing happened or if those two things were related. We know that they're related because he said they were related, and they are the same nature of substance, and they demonstrate his familiarity with contraband. It sort of illustrates that he knows what's going to be in this box. And it was also, of course, probative because he gave this confession. So this video is corroborating his confession. Here's a real thing that happened that has a date stamp of August 24th in the phone that the jury can look at to see, okay, the things that are said in this confession, they relate to the real world. There's a way to evaluate them. That corroboration is critical. It also gives them everything that they need to resolve the issues that my friend on the other side raises. There is no confusion of the issues or prejudice that outweighs the probative value of that video. There's no trial within a trial or separate trial.
Counsel, and I just don't recall this, and maybe you do. Was there a 404B argument made, or was it only 403?
No, this was offered as intrinsic evidence of the possession with intent to distribute. So it was offered as relevant and probative of his intent.
What I'm asking is, did the defendant object under 404B and say it's not intrinsic, it's other bad acts evidence?
No, that was not raised as an argument at all below. So this was offered as linked, substantive, probative evidence, and there was no objection raised that, in fact, it's actually prior bad acts evidence. And I think it's important that all of this stuff came together and was all obtained on September 8th. And that's why there's no confusion and no need for a trial within a trial, because everything that is needed to know about the DHL video comes from the defendant's own words. He tells the investigators.
And I don't want anything that's not in the record, but did the record reveal the metadata of when the video was taken?
There was testimony about the time stamp of the video in the file structure. So it was August 24th of 2017. It didn't go as granular as looking at the metadata to see when it was recorded. That's the only information that's in the record. 2 weeks before this incident. Correct. So yeah, it's about 2 weeks before this. He's the one that brought this video to the officer's attention. It was central to showing his level of knowledge and to sort of discounting the ultimate defense, which was that he was an unwitting courier, that he had no idea what was in that box. He had never looked in the box, no way to know that it had drug evidence. So it was critical to proving that he knew what was in that box. And that's why when he lied about that video and he lied about what he knew about it, it was perjury, and the obstruction enhancement was appropriate. He claimed falsely. Yeah.
Counsel, I want you to finish what you need to say, but I got a question about the enhancement, and you only got 4 minutes. So if you would kind of, I want you to finish your thought, and then I'm going to ask you a question about that, but I don't want to prevent you from finishing.
Understood, Your Honor. Understood. He lied and he claimed that this video was only recorded so that he could show it to police because he was angry about getting a box of drugs sent to him unwittingly, and that he was under stress or duress or fear. And the judge made detailed findings that that was false and it didn't match the video itself. The judge below found that his statements in the video, his demeanor, the calm way he spoke, albeit in the Spanish language, his gesture of giving a thumbs up that he felt success or pleasure in opening this package successfully, that contradicted that testimony. And the reason that testimony was offered was to take away the mens rea, was try to discount that he had any knowledge of drugs or any intent to distribute them. So it was key evidence and material to what was testified to. And just like in the Sun case, that is the heart of the case. There wasn't sort of an argument, did he have the box? There was an argument, did he know what was in the box and was he willingly trafficking it? And that video shows us, yes, he was. And he lied about why that video was recorded to try to take that element away. To your point, Your Honor, ultimately the court imposed a very reasonable and well thought out sentence in this case, 121 months, which was 1 month greater than the mandatory minimum. But importantly, it was within the guidelines range, both with and without.
So my question on that is, do you think the judge made a finding on willfulness? Do you think, the statement the defendant did not tell the truth constitutes willfulness? And if it doesn't, do you think that is improper under, I think, what would be plain error? But or tell me what's our standard review and how we should look at that.
Your Honor, the standard review here is whether there's clear error. And candidly, we'd ask this court to give great deference to the judge's findings because he had a bird's eye view of the credibility of the video of the defendant as he testified and the appearance of that video. So he testified that the defendant testified that he had recorded these things under a particular sort of set of emotions and that didn't match the video. And the judge ruled that this was material because it went directly to the knowledge and intent. And of course, this is after a direct examination and then a cross-examination and a redirect examination where he maintained.
Let me stop you. I don't know if I asked the question right, or my question is, did the judge make a finding on willfulness in your view? Let me just go one at a time. Do you think he made a finding on willfulness?
I think he made a finding expressly that he found this to be a false statement that the defendant made. I don't think he said the words, this was a willfully made false statement, but of course he was able to see the defendant testify and make this statement freely. So I think that's implicit to the finding that he makes, which is a false statement was given that doesn't match the videos that I watched, essentially.
Was there an objection, and your colleague may want to talk about this in his rebuttal, was there an objection to his lack of finding of willfulness? And if so, would we view a challenge to that under plain error?
There was no objection made to any particular finding of willfulness or not. There was sort of a factual argument about whether it was factually true that he showed the video later on to law enforcement, and the judge essentially found that that was not credible because he didn't show it in the interview in time. So there wasn't an objection. Ultimately, there's not a plain error here that needs to be corrected by the court because it was a harmless error. And it did not enhance the district court sentence, and the district court made a detailed ruling about the 3553A factors. It stated that it would give the same sentence, 10 years and 1 month, with or without that obstruction, without the perjury. My time is up, Your Honor.
Right.
Thank you very much for the time.
Thank you very much, Mr. Guillaume. You have some rebuttal time.
Yes, thank you, Your Honors. Your Honors, listening to my colleagues' statements here, I'm focusing first on the probable cause. I have not heard the probable cause that the government relied on to search Mr. Gondes Medrano. Judge Quattlebaum, you brought up a moment ago the fact that there was a tracking warrant. Your Honor, I would submit to you that the tracking warrant, with the probable cause for the tracking warrant, does not carry over for the probable cause to eventually search Mr. Gondes Medrano. That probable cause that for the tracking warrant, which we did not contest, simply was to determine whether Mr. Gondes Medrano was in fact a drug dealer, because as this court knows, there are times when even an informant without bad faith may be wrong about a particular individual. So that tracking warrant.
You agree that the problem that in order to get a tracking warrant, you must have probable cause that he was trafficking drugs. That's what the probable cause for the tracking warrant was, right?
Suspicion thereof, Your Honor. It doesn't necessarily mean that it is true, because one would never know.
Your position is you can get a tracking warrant without probable cause?
I think that the magistrate has to have reliable information, but that reliable information does not necessarily extend indefinitely. And in this instance, the officer had probable cause at the time to get the warrant, but by the time that the search was done, there wasn't enough to, in fact, search Mr. Gondes Medrano, which is, I mean, I'm just speculating here, but potentially why they showed up with an immigration warrant as a back, why he was arrested. He wasn't arrested for any drug activity. They didn't have anything drug related to arrest him for. So it's like a back door into getting into that shoebox, Your Honor. But there's no specific instance of criminal activity that the government has cited. With respect to the arguments made with willfulness that the court has just raised, I would submit to the court that I did not make an objection at the time, but I believe a plain error analysis would in fact apply in this case with respect to that enhancement, Your Honors. And also just focusing quickly on the issue, I think Judge Richardson kind of touched on it and said it more better than I did, which was the amount of heroin in that video, the 333 to the 792, and the testimony that follows kind of encapsulates our argument with respect to how this was a confusing issue for the jury, because the government took a stand but then backed away from the stand and said, well, you guys can kind of figure it out. And my client actually gave a very detailed description about what the issue in this case, what happened to those drugs. It was not whether they were drugs, it was what drugs belonged to whom and at what time and what was done with them. So he never denied possessing drugs on multiple occasions. So it wasn't necessarily a 404B argument, it was a 403 argument, Your Honor, just to clarify. Your Honors, I am asking that this court declare that the search of Mr. Gondes Medrano's shoebox was unlawful. I'm asking this court to rule that the district court abuses discretion by admitting that video of Mr. Gondes Medrano. And I'm also asking the court to rule that the district court erred when it enhanced Mr. Gondes Medrano's sentence pursuant to a obstruction of justice enhancement. And Your Honors, I don't have anything further. If you have any questions for me, I would take them at this time.
Thank you very much. Don't have any questions. Yeah, thank you very much for your arguments here today, Mr. We all might see that you're court appointed, and we appreciate your service. We obviously couldn't run court without attorneys like you. And we would ordinarily come down and shake your hand and tell you what a good job you did. But you just have to take a virtual handshake from us today. But we do appreciate your arguments. Thank you very much.
Thank you all.